Hello, I'm Dan Marr from Hamblett Kerrigan in Nashua, New Hampshire, and I'm going to be talking today about bonuses and commissions in your employment and your entitlement to them under New Hampshire and Massachusetts law. We're going to be talking about those. Basically, sometimes you have performance bonuses where the company has created a formula upon which you're determined to be getting your bonus usually at the end of the year. Or you might be getting commissions. You might be getting commissions on sales that you produce or your group produces if you're a manager. And in those circumstances, those are wages under New Hampshire law and Massachusetts law. And both New Hampshire and Massachusetts have formats to protect the employees. Basically, in Massachusetts, there's the Massachusetts Wage Act, and and you get 3 times, if you follow certain procedures, you get 3 times the wages they're due if they don't pay you. Even if they thought they were doing it in good faith, they might still have to pay the 3 times based upon Massachusetts law. You have to go through a certain process to do that. I'm licensed and practicing in both states. I've been practicing since 1996 in Massachusetts, and 1987 in New Hampshire. So I've been practicing for a while. All been primarily here at Hamblett Kerrigan, and I'm happy to help. I practice actively in both states. But for the bonuses, if you have a situation where you have a clear formula, it's not discretionary, because sometimes bonuses are based upon the discretion of management. In that situation, it's a lot tougher to show that that's a wage, where it's more of an illusory promise because they can have the discretion. But when they say discretion, you might want to talk to an attorney if it's substantial to see what their discretion is. But for the most part, if it's discretion, you don't have it. But you may be in a situation where if they alter your situation so that your performance doesn't meet the criteria, and they say, well, that's in our discretion, there might be something called the implied duty, good faith, and fair dealing. Massachusetts has some case law that's pretty clear on that in the employment context. There's some on wages where are commissions where the person is clearly under the agreement not to get commissions on a sale if they leave when the sale is due, when the sale is being paid, and the employer goes and says, well, wait a minute, we don't want to pay Bob on this $5 million sale. We don't want to pay him a commission, so we're going to fire him. Even though he's a great employee, we're going to fire him just so we can get out of a significant commission, maybe a $500,000 commission it might be under our program. In that situation, Massachusetts has recognized, and I think New Hampshire may recognize it, we haven't established it yet in the courts in New Hampshire, implied duty, good faith, and fair dealing, where if you're firing somebody just to get out of your contractual obligation, that might be a problem. So Massachusetts is clear, New Hampshire not so much yet, but I'd be certainly willing to take that to the courts if the right case comes about. And I do these cases on the right cases on a contingency fee basis. Both bonuses and wages are recoverable attorney's fees, but your attorney's fees that you'll get in that situation will be based upon hourly amounts. But I am in the right cases considering contingency fees getting 1/3 of the take, which would be including the wages and the attorney's fees. So if there's a recovery of, say, $100,000 of commissions, and there's a recovery of $10,000 of attorney's fees, I would get 1/3 of the $110,000, the 100 plus the 10. But I'm willing to do those in the right cases. And then the benefit of a contingency fee obviously is that the employee who's just lost their job or left to go to another job doesn't have to pay for those attorney's fees. And that's, I look at those cases and make a determination when I think they're worthwhile to do on a contingency fee, but that can remove some risk for the employees. So these situations also in New Hampshire, commissions are generally due when the company has accepted the order, absent there being a clear written policy or a procedure that the employee knows about to the contrary. So you may have a situation where you have a regular commission, you get 10% commission on sales, just throwing that example out. Probably more complicated than that, but 10% of the sales that you have, you get a commission on. And that's very generous, but that's probably not the level. But at that 10%, you get that, and you book a sale for $500,000, and the company goes and you leave the company, maybe you leave voluntarily to go to a competitor, they've accepted the order, but later on, when the order comes in, they don't want to pay you because you've already left. Maybe you've left it for a competitor and they don't want to pay you. In that circumstance, absent there being a clear policy, there is some case law out there that says that you're entitled to that commission. So, you should talk to a lawyer about that. I'm interested in these cases. I've represented a number of employees. I've also represented employers on these situations. There's both the New Hampshire Department of Labor in New Hampshire, as well as Superior Court. Sometimes these more complicated cases, if you need some discovery, I prefer to be in the Superior Court. But we can talk about that. I'm here at Dan Marr at 603-883-5501, 603-883-5501, or you can check out our website at hamker.com or nashualaw1word.com. Look forward to talking to you and working with you if the opportunity arises. Thank you.